I had you two here before.
In October of 2024, the case was finished.
I understand your legal argument.
I don't make legal arguments.
Well,
I make rulings.
I want it to end.
I've been doing this kind of work for 50 years.
Not very well if you're doing it this way.
But if you don't have the certificate of compliance, you can't rent it. So how much rent did she pay?
Gil Stanford has a problem, and it isn't his former tenant, Susie Norman. No, Gil's problem seems to be that he's a greedy landlord, having another crack at suing Ms. Norman for damages to his property, even though they settled dueling claims 2 years ago. Gil has more problems too. He claims $1,000 in labor spent getting rid of her stuff, while Ms. Norman says the city removed all that stuff for free. He says he spent thousands repainting the place she occupied for only 6 months, and he claims she owes $1,800 for 2 interior doors that took him 18 hours to replace. But those aren't Gil's biggest problems. His biggest problem is that he collected over $15,000 on a property he wasn't legally allowed to rent. Let's roll, nerds.
I had you two here before a long time ago.
Yeah.
7 times.
Ms. Norman, what's going on from your position in this?
Well, it was my understanding that in October of 2024, the case was finished. 7 times we came in front of you. I had a case against him. I dismissed it for the possession. It was a possession case. I had a case that showed that he had no certificate of occupancy. The house was not habitable. And now here we are again.
So what is your claim, sir?
My claim is for physical damages that her and the family caused to the property and lost rent.
What happened to, in the month she left, what happened to the security deposit?
I asked me,
Yeah.
she did not have enough money paid into to fund a security deposit. She did not have that initially when she first moved in. She was trying to get caught up on that, but she never had enough money. But there was not a security deposit.
Okay, well, here's the other issue. As I'm recalling in the case, and it's all kind of coming back based upon some of the things you're saying, the house did not have a COO.
At the time, during the course of her tenancy, I was not aware that it had expired, and you're correct. There was not that COO. After she moved out, I made the corrections, and I have a new COO. And I think,
But during the time that she was renting, you didn't have one.
that's correct.
And this is in regard to the rent claims. If at the time she occupied the premises, you don't have a COO, and as such can't charge rent, theoretically, how do you then at some point begin charging her rent after she's left?
Because we had a lease that went through
But
August.
the lease is going to be void, sir, because you don't have a COO. You can't enter into a lease.
Well, that was a contract that we agreed to. And
Okay, you can agree to whatever you want to, but you're asking this court to basically enforce what may be an illegal lease. But what you're then attempting to do is take part of that after you've had an agreement regarding her leaving the premises. She leaves the premises, you then make your corrections, get your CEO, and now want to charge rent on a lease that was probably void from the beginning.
I guess the question is,
No, I like my question better. And that is, how do you do that? You can't rent the premises, which means, since you can't rent it, then my question to you would be, if that's the case, how can you sign a contract to rent the premises?
well, we did that. She moved in and she damaged the property.
Then it gets even, because in the 2024 case, which I understand why she wants to reopen, the claims were basically dismissed, rent waived. There was then a split of the escrow. So at that point, the relationship from a tenancy standpoint ended. If you couldn't charge rent from the beginning, how can you then decide to charge rent?
I see what you're saying. I understand your legal argument there, and
I don't make legal arguments.
well,
I make rulings. So now that's what the fight is. When she moved in, was there a rental check-in?
I don't believe she ever filled one out.
So where is this one coming from?
I have one that I filled out when she moved in. I have another one filled out when she moved out. There, I have my copies of that document.
Did you send her a list of the damages you're claiming?
I did.
All right, Miss Norman, what's your response to the damages?
Well, first of all, I did fill out the inventory checklist, myself and my daughters, and I did submit that to him.
Did you get a list of the damages that he's claiming?
No, I did not. What I received was the filing from 6/3 for the damages. He never returned any of my security deposit, so he's incorrect. So I did not receive an itemized list within 30 days. The first time I'm hearing.
Did he have your forwarding address?
Yes, he did. And so did Mr. McCurgy, who was an attorney for him at the time.
Graham, how much are you claiming you paid in the security deposit?
$3,500.
Sir,
Yes,
do you agree that she paid $3,500 in a security deposit?
I do not agree with that.
How much do you think she paid in a security deposit?
I have to review my records, but I think it was.
Hold on. When you sent out the sheet to her, you had to subtract out, you would claim damages, and then you had to subtract out what you had.
And I had no money in security deposit because
Well, hold on a moment. You just told me a little while ago that you did because she didn't pay it all.
when she moved in, she did not have enough money. All of the cash that I provided for her to move in, she was short the money that would be for the security deposit. She said she was going to pay that and get caught up on that, but she never got caught up on that. So she was all.
So she's saying she paid $3,500. You're saying she didn't pay any.
She did not pay $3,500
Different answer. Sir, hold on,
to me.
because you told me two different things here today, at least.
I don't believe she paid the security deposit. I don't believe she paid enough money at move-in to cover.
How do we not know that?
What's that?
How do we not know that? We being figuratively, how do you not know that?
Actually, I was on a travel assignment. I'm a travel nurse. I was on a travel assignment and I sent him $4,000 to hold it. So that was over the $3,300 first month's rent. And then when I got there, I paid him $1,750.
So you gave him $5,700 at move-in? Okay, here's what I'm gonna want. No, we're gonna stop today. I'm gonna adjourn this out. You are to supply to Miss Norman a list of the damages you're claiming. Understood?
Understood.
I also then want an accounting from the landlord of all monies paid by Miss Norman.
Okay.
I then want the previous tenant's inventory checklist as well as the previous tenant's inventory checkout list and the initial and concluding inventory checkouts for Miss Norman. Understood?
Yes.
Judge Simpson, will you rule on the motion to reopen my case? Part of the reason why this journey started was because the house was inhabitable and I called the township for an inspection.
Go ahead.
I see your hand go up, so I stopped.
Yeah, I know. That usually means be quiet, but I realize you're on Zoom. But go ahead. I'm listening.
Okay, so that is all of that information and damages and mold and all of the things I have photographs in that file.
I know. I know that that exists. I don't know for the purposes for which you want to use it for that I need to necessarily reopen the case. At this point, I am going to deny your request to reopen without prejudice, meaning at some point, either the court or you can raise that again and I may reopen it. Okay, folks? Court does call the case. Gil Stanford versus Susie Norman. And where are we on this case?
I submitted to the court a bunch of information that you requested.
Hey, Ms. Norman, do you have a response to these documents?
Well, I do object to the damages that he's claiming. I would like to just say that I thought that the matters between Mr. Stanford and I concluded in October of last year. If this is going to proceed forward, if I could ask the court for time to be able to submit my evidences.
I'm going to let her submit that so you can take a look at that and the court can take a look at that. Because I'll adjourn this matter then to these matters to January 27th. Let's call the case of Gil Stanford versus Susie Norman. Now, folks, where are we on this case?
In my evidence that I mailed are the flash drives with the video on it of when Mr. Stanford and myself was in your courtroom on 10/22 of 2024. And you asked Mr. Stanford 2 questions. 1, are you waiving rent? And 2, are you waiving monetary damages? And he responded yes to both of those.
Okay. But Ms. Norman, just so that I'm clear, I think I can't do much today, I don't think, because I think Mr. Stanford's indicating he can't open the flash that he has, and I don't have it. I'm going to give you guys an adjourn date. All right. I'll adjourn this out to February 10th. Stanford versus Norman. All right. Where are we on this case, folks?
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent.
Ms. Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. Mr. Stanford has submitted something. So what I'm going to do to expedite the process, Ms. Norman, I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it.
So what he's saying, he's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Ms. Norman, I can't force this to go any different.
I don't want to argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to proceed with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
I'm going to tell you this, and then I'm not hearing anything else from you. I'm going to do what I'm going to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail.
I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Give me a date. I'm done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out. Stanford versus Liver. Why do you believe that the resolution of the last case did not resolve these issues?
She still occupied the property.
So the entirety of the amount, is that all damages that you're claiming in this case?
What I have submitted.
And remind me, how long was she in the unit?
How long she was in the unit? She was in the unit from 3/23/24 and until October 31st.
When was the last time the unit was painted before she moved in?
Probably about a year before she moved in.
And then she's there 6 months. So why is she paying the cost of repainting? So I'm trying to figure out. There were items that had to move out. Who moved those items out?
I had to.
So how do I get to 1,090?
Well, that was the labor involved. I had a total of 10 and a half hours moving that stuff out, loading it up, hauling it away at dump feet.
So what was the hourly rate you charged?
What we have agreed to in the lease was $100 per man hour.
Yeah, but what were your actual hours?
The hours? Well,
I mean, all of the labor in here, was that done by you?
or some of it was done by me personally, but most of it was my people that work for me. I can provide.
Where were these doors? See, I'm going to tell you right now what I got a problem with. The time it's taking to do these things. I mean, you're charging $100 an hour, which is a little odd to me because if you were to hire somebody, that normally would not be the cost.
Well, it wouldn't. Well, it would be if I.
No, it wouldn't.
If I hire a handyman service to come in and do these repairs, the local handyman companies are charging in the area of 100, 125 per man.
But they do it quicker. You're going to tell me it took you almost 18 hours to replace doors?
That's a lot of work, placing a door.
You know, that's a funny thing. Everybody thinks as a judge, I don't do anything. I just go home, crawl under a rock, and I never repair or do anything. If it takes you 18 hours to install 2 doors, you better have reinstalled the frame, had to knock it out, put wood in. There is no way it's going to take 18 hours.
It's the cost of doing business. If I came to your house and put a door in, I got to include the cost of me going to the lumberyard, buying that door, delivering it to you.
Well, if it takes you 18 hours to put in a door, you're not coming to my house to do it.
You know,
Maybe you're not understanding what I'm saying. What I'm saying is you're trying to charge for time that seems to me to be extra time based upon the way that you did it.
I've been doing this kind of work for 50 years. And,
Not very well if you're doing it this way.
well,
I'm done with you. Don't say a word to me. How is the plumbing her fault?
they had a bathtub that was back up. And they were doing something to it and they broke the trap. And I had to go back in and fix a bunch of drywall that got damaged and fix the plumbing.
What portion of the lease has that $100 labor charge? Which I'm not sure is legal, but go ahead.
The portion in that lease said if there's damages, they can repair them, or if not, they agree to hire Stanford Enterprises to take care of their.
In the lease, they can't get somebody of their own choosing to do the repairs.
No, they can't.
Well, what's this about hiring Stanford Enterprises?
Well, if they don't fix it, I've got to have my crew go in and do the repairs. If they do damages and then walk away.
Where's the $100 thing? It says tenant will pay the company's standard rate, current rate, is service and trip charge of $50 plus $100, right? Per man hour. Ms. Norman, you got anything to say?
I do. So just kind of going back to how when the case started and that last case that we had the consent order for, he talked about I believe he's talking about number 6, the defendant may be liable for damages. I was concerned about that and voiced my concerns to you, and you specifically asked him on record if he was waiving rent and monetary damages, and he said he was. His counsel was there with him. Also, what got us into court was because the property was damaged in the first place. And I did ask the court if I could reopen my case since Mr. Stanford was bringing this back into your court. And at the time you denied it, and there's photos of the damages.
Up on move-in.
Correct. And I called the township myself for the inspection. So there was a lot of things he had to fix, and then he didn't have that certificate of occupancy as well. My deposit was $3,500. Let's see. And he's talking about this big plumbing issue. I called him the moment that started leaking. I don't even believe we were in court at that time. He came there and I asked him to remediate that water or if he had a shop vac, and he said, "Don't you have a mop?" So that was a whole thing, but I was not trying to fix that. I'm not a plumber. I called him immediately. I'd like to just address quickly the amount of monies he's trying to charge me for.
Hold on a second,
Okay.
Norman. I now see that. How much was the monthly rent? I just got to update myself on that.
The monthly rent was $3,300.
So in all of your, I'll come back to you in a moment, Ms. Norman.
Okay.
In all of your estimates, there's a $3,500 security deposit, not the $1,050.
That's right. The lease called for $3,500, I believe. She had not paid the full deposit.
So why did she move in?
Well, she wanted to move in. I gave her a break.
Then why wasn't the lease changed to reflect that?
Well, she had agreed that she was going to get caught up and pay the difference on that.
By when?
Well, we had.
Is there anything in writing to that effect?
We have agreements that.
Was there anything in writing to that effect?
There was some random things that communication that we had back.
Okay. If you want to play semantics with me, we can play it all day because I bet you I could beat you. Do you have a signed writing indicating anything about that security deposit that's different from what the lease says?
I have records showing what she paid. I don't have a written agreement of what transpires.
So the answer to my question is no, I do not have that.
No.
Were you able to find it?
So Mr. McCurgy was present at that hearing, and he says, "We're not claiming money damages for rent. This is only a claim for return of property."
He's making claims that the furniture, removal of the furniture, he calls the city to have that removed for free, because when I moved in, there was furniture sitting in the driveway, and he informed me that these bulky items, all you do is call and they remove them for free. So I'm under the impression that that's what happened in this case as well. I didn't see any receipts in all of the items that he sent.
You didn't have a certificate of occupancy?
The township failed to follow their procedure as far as renewing that.
So the answer to my question is no, you did not, which means you could not rent.
When she first gave me,
Which means, correct me if I'm wrong, that you could not rent that property.
technically by law,
That's what I deal with. You know, you can call it technicality all you want. That's what I do.
And Your Honor, I don't believe that the failure of the township to do the what they are
Then
statutory.
you may have a claim against the township, but if you don't have the certificate of compliance, you can't rent it.
And I wasn't aware of that when we signed the lease.
Okay. So how much rent did she pay you? Because if you can't rent it, you can't charge her rent.
I submitted some information on how much she paid.
Well, wouldn't it seem to you if you can't charge rent and you can't rent it at that point in time, that you might owe her money, or that at least gets offset as against any claim that you have?
Is that question or?
Well, it might
I
be a
didn't-
statement. If I make it a statement, we're done here. Monthly rent was about 3,000 something.
3,300.
Okay. If she paid rent to you at a point at which you can't rent the property nor take rent, then wouldn't you owe that back to her?
I don't think the burden should be on me for the failure of the township.
Again, you might have a claim against the township, but you don't have a claim against her.
Well, I think I do.
Okay.
Judge Simpson?
Yes, ma'am.
Just so you know, I paid him. It's in the case that I filed before, around $15,000, and all my money orders are there. Everything is there. But just so you know.
In the previous matter, right?
Yes.
I know that based upon my memory of the previous case, you paid the money. That's not my issue. My issue is monies that you paid that maybe you shouldn't have paid. So what I'm going to do is 428. I'm going to set a non-jury trial. I'll need the parties here in person. I was going to set it for April 28th. And what I might suggest, Mr. Stanford, is that you look at how much she paid during the time at which your property did not have a COC or temporary COC, and determine whether or not you want to head forward with this case, because it may offset anything that you might be entitled.
Understand.